Hello, my name is Shalini Bhutani. I'm a legal researcher and policy analyst. I work on issues of law and their interface with communities and conservation. I've been looking at the issues of biosafety for almost 2 decades now, and that's what I'll be sharing with you today. The whole issue of biosafety and the legal concerns that surround them. So let's just try and capture for you what is the scope of the presentation. We'll start with trying to understand the concept of biosafety, look at the role of law in current day science and technology. We'll also take a glimpse at the international law on the subject of biosafety. We'll then spend a few moments on the Indian situation. And apart from the laws and regulations, we'll also take a look at some of the court cases on this issue. And we'll wrap with some of the related laws apart from those concerned specifically with biosafety, and try and give you a complete overview of the issue of how it's developing. Okay, to start with, what do we understand by biosafety? When you use the word bio, it kind of indicates living organisms, and safety, as you know, talks of security. But this is biological safety, which means the safety, issues of safety around living modified organisms. So, living modified organisms, the processes that make them, as well as the end products called living modified organisms, are all products of modern technology. And so you need law on LMOs, not only to regulate the safety of those handling LMOs, that is the scientists in the lab, but when that LMO is released in the open, so in the open society, in a natural environment. So a biosafety law essentially captures the relationship between science and society. And LMOs, living modified organisms, which are also interchangeably used with the term GMOs, are made by human intervention in naturally existing life forms. So the important thing to understand when studying a law on biosafety is that the law has to deal with living forms that nature has not made. So we are dealing with, in a sense, unnatural living forms. And what are the most talked of examples of LMOs and GMOs? Because these can be developed in any sector, whether in agriculture, in forestry, in fisheries, used for industrial application, or for pharmaceuticals. So there's a whole range of how LMOs are used in different sectors. And so there would be sector-specific biosafety regulation. But let's just look at one of the most controversial examples, and that is LMOs or GMOs in the seed sector, and that is genetically modified crops. And the most talked of amongst those is transgenic cotton, which has the gene of Bacillus thuringiensis, which is a living microorganism found in soil. The gene of that inserted into a cotton genome. So yes, it does take a lot of understanding science apart from just being a student of law. And so it's easier to then draw the linkage between the developing law and the developing science. And this is an example where law has had to keep pace with so-called modern technology, because living modified organisms are something that are believed to have developed from modern biotechnology. And since they are unnatural, have not existed in nature before, they interact in unpredictable ways with the natural world around them. And that introduces the element of uncertainty. This is a key issue or a key challenge that biosafety laws have to deal with. because then the law on biosafety would need to provide for not only risk assessment of how do you assess the risk of GMOs and LMOs, and also the risk management. And these have been recognized internationally as focal areas for capacity building for all the countries that have to deal with the issue of biosafety. In the law that is developing within India, which is the Biotechnology Regulatory Authority of India bill, there is a specific provision to set up a risk assessment unit for purely science-based safety assessments. But there are much larger public concerns beyond the science, which means other considerations need to be brought into the picture and thoroughly examine GMOs from the point of view of socio-economic implications. This is also a call being given by civil society as well as concerned scientists within the community itself that is developing GMOs. Now, the international law on the subject is contained in the Cartagena Protocol on Biosafety, and I start with that because that's where the definition of an LMO is given, an internationally recognized definition of LMO, which is any living organism that possesses a novel combination of genetic material obtained through the use of modern biotechnology. Then how does biosafety become a legal issue? And when does a problem get picked up for policy making and law? Because there is a lot of activity world over around making of laws on biosafety. But the fact that it has all these risks and these uncertainties that need to be factored in, and also because law inherently is about the establishment of normative values, means it helps to move from what is the current situation to what ought to be. So biosafety means what is the level of safety that ought to be when we are dealing with LMOs. At a practical level, a biosafety law will have to provide for the protection of human and ecological health, and that is the core objective of any biosafety law. But not only is the issue of LMOs or GMOs challenging, it is the aspect of GMOs that makes it, there are several aspects of GMOs that make it such a challenge for lawmaking. Firstly, because of the inherent internal nature of the issue, which means you can develop an LMO, you can be the best scientist to have developed it, you can write the perfect law, but bees and birds don't follow or don't read biosafety laws. And so there are inherent limitations of the technology itself, and when the technology is released in the open environment. And the fact is that the law cannot control every natural process happening naturally in the natural environment. And therefore, that creates a certain limitation for the law itself, that you can only regulate that much. Also, in the open environment, apart from the natural environment, the political environment itself has changed. So you have to situate the issue of LMOs within a world which has gone through a paradigmatic shift. In the political economy, GMOs is not simply a product of science. It is actually a product of technology, which is the commercial application of that science. At a time where capitalism and products to be sold in the free market are given much more protection under a legal system than perhaps social and ecological considerations. So what role can law play in this, whether that's the national law or the international law on biosafety? Like any other law, a biosafety law would also need to regulate human behavior. It would then also need to prescribe rules by which it seeks to regulate human behavior. And if there is any digression from any of those prescribed behavior, then the law has to impose penalties and be able to pin liability as well as be able to get redress for any kind of damage that might result from LMOs or GMOs. So what are the possible legal approaches that a legal system can take? Because different countries in the world have different positions ranging from for and against LMOs. There are also very vibrant social movements on this issue and much activism within the legal circles as well. And it's good to get a flavor of the different positions that people can take depending on how comfortable they are with the idea of commercializing and using LMOs in different sectors. And a country's legal system can choose to say no through its biosafety law, and even if it says no, it still needs to regulate human behavior so that having declared itself to be GMO free, it would then pin liability or responsibility on those who introduce LMOs into its GM free area territories. Or through a biosafety law, a country could impose a moratorium, which means to say, to signal that they're not yet ready to go out for a full-out application and use of this technology. They could also take a more cautious approach, which is a yes-but approach, which means let's do a case-by-case assessment of LMOs and GMOs and then verify and be satisfied by their safety, and only then release it after putting them through an independent assessment procedure, which also looks at socioeconomic considerations and not only from a scientific point of view. Or a fourth legal approach that a country could take would be to be completely pro LMOs and say, yes, we are okay with going ahead with using and commercializing genetically modified products of all kind in all sectors, and therefore we need a biosafety law only to regulate the use and to ensure that once it's being used, it is done so safely and with due precaution. Which brings us to the environmental law principles that are supposed to underlie any law, whether it's a national or the international law, on biosafety.